thank you everyone for joining us today. Today we're going to talk about handling of personal data. I'm Enrico Gleri, I'm a staff scientist at the School of Science at Aalto, and I'm also one of the data agents. Glerian is my Twitter handle, and on my Twitter you can also find these slides that I'm using right now. And with us today we also have Maria Rebinder, who's a senior legal counsel at Aalto. She's an expert of personal data for research, and she's been drafting all our privacy notices templates and many other useful information that you will find today. All right, so the outline for today's workshop, basically we will start by defining what we mean, what are personal data and why do we need to handle them differently. And then I will kind of give a sort of an intuitive step-by-step process that kind of follows the order of things that you need to prepare and that you need to be aware of when you handle personal data. And then we will stop the recording and we can have open questions via chat or you can talk. You can already, of course, use the chat and write the questions, and we will go through them later. One small remark that what we cover here is personal data in research. So similar consideration can apply, of course, for other type of data that are not research data, but that's a different topic here. We are basically discussing about personal data used in research for research purposes. These slides are open. I gave you the link. Feel free to reuse them, and also thanks to past people who have been contributing to these slides. So if you need a reference, if you're in a hurry and you have to leave right now, the first link that you see in this slide, that's all you need. In this page, you find most of the links that I've listed here in the slides. There's the full process, step by step, and even more interesting links from the European Data Protection Board and also the Finnish Ombudsman, the Data Privacy Ombudsman. So if you're in a hurry, that's the link, this first one here that you need to know. And then from the FSD, they also created very useful web pages on personal data and, for example, anonymization and identifiers. So that's also another very useful link. If you have questions, if these resources, if these two links don't have the answer for your case, you can always send us an email at researchdata@aalto.fi, and then you will hear from us, and we're always ready to help you. All right, so let's start with the kind of definitions with what is personal data. So personal data is a broad concept under the EU's General Data Protection Regulation that we also know is known as GDPR. So personal data is any data about living people from which they can be identified. So as I was showing earlier in the example, any type of data that can be linked from a person, that is information from a person or of a person, can be considered personal data. The only type of data that is not personal data is anonymous data, which basically means that it's absolutely impossible to re-identify somebody. So in general, there are different types of identifiers that we can basically separate the different types of personal data. There are the so-called direct identifiers, which is basically information that is sufficient on its own to identify an individual. This can be the person name and surname, an email address, for example, name.surname@aalto.fi, or social security number, fingerprints, facial images, the image of the eye, the voice. So all sorts of fingerprinting that are direct identifiers. There is, of course, also other type of personal data that are called strong indirect identifiers, which basically mean, it's not exactly written the name of the person, but with that information, let's say the postal address, your home address, with that information, it's not too difficult. It's fairly easy to see who lives in that house. Or the same can be a phone number or the registration number of a car you can just text the registry and they tell you who is the owner. So all this type of identifier, they are called strong indirect identifiers. Location data, online identifiers, for example, like the internet protocol address, which is the unique address that we get with our device, mobile phone or laptop or computer when we connect to the internet. They are also strong indirect identifiers. So from your phone connected to the internet, not always, but it can be. Usually, it's fairly easy to re-identify somebody. And then there are also a third type of personal data, which are so-called indirect identifiers. So indirect identifiers, they are more weak type of personal data, because if you consider them on their own, for example, just age as a number or age as an age group, it doesn't really tell you much about the person. But with enough indirect identifiers, if you start adding age, gender, education, status in employment, etc., you might basically start to, it's like the game of guess who. I don't know if you ever played Arva Kuka in Finnish. So with enough questions and with enough information, you can single out the individual. So are there techniques to reduce the risk of processing to the data subject? So it's important to also define two types of techniques: pseudonymization and anonymization. With pseudonymization, the data are still personal data. So pseudonymization, also called minimization, is basically saying that we start removing some of the data from the subject, from the personal data of the subject, so that it becomes more difficult to re-identify the person. So, for example, blurring of the faces in a video. But that doesn't mean that it's completely anonymous, because maybe even though you blur the face, the body is still visible, and from how the body moves, you can still identify somebody. Instead, the other type, which is anonymization, then the personal data is being kind of processed so much that it's impossible to re-identify. And with impossible, literally mean mathematically impossible. That with given one bit of anonymized data, you know that there are, for example, at least 5 people or more that have exactly the same data. So for anonymous data, the GDPR does not apply. So when it comes to the practicalities on pseudonymization, basically what I was saying earlier, that we can remove the identifiers, or we can replace some of the identifier with pseudonyms or codes that can be kept separately, because sometimes we still need to re-identify subject. For example, let's imagine that you run a longitudinal study where you invite somebody over the years to your experiment. Then you still need a way to know who is who, but you might keep the key in a secure place, while you might use a pseudonym or a different code for knowing that subject one corresponds to whatever social security number stored in a secure place. So the data are basically called pseudonymous as long as the additional identifying information exists. So as long that there is a way to re-identify somebody, as long as the key is still there, then it's still personal data, even though it's pseudonymized. With anonymization, instead, we basically destroy the personal data. We irreversibly remove identifying information from the data. And what is usually written is, or what we usually mean is that it's reasonably likely that, how can I say, that this would basically mean that kind of that we can consider that it's very unlikely to be re-identified, if not impossible, mathematically impossible. And then the data, we can call it anonymous data. And of course, it's always tricky with anonymization. I usually say that the anonymous data of today is the personal data of tomorrow. There have been many cases of data that would have been considered anonymous, But then when we start to link it with other data sets, we might make what we supposedly was anonymous data might become personal data again. So it's always tricky, if not close to impossible, to make data fully anonymous. So the GDPR recital 26 regarding anonymization specified that it's important to take all the factors, especially what the available technology of today. So if today we are fine in calling something anonymous with whatever technology, of course, we cannot predict that maybe in 10 years or in 20 years, there is some whatever fancy machine learning method that is able to re-identify anonymous data. But of course, even though this is what the law is saying from the ethics point of view, you might still not want to promise your subject full anonymization if you are unsure yourself if it can be fully anonymized. So it's always safer to treat the data as personal data. And then at the very end of the process, when you are kind of ready to destroy part of the data, you can make it anonymous and, for example, share it or use it for other purposes. All right, in general, if you want more information on personal data, what you see here is also findable in the Finnish Ombudsman for personal data, and there's the link there in tietosuoja.fi. For those at Aalto, we have a My Courses course that covers these things, especially section 4, so you can click the link from the slides. We already talked about the FSD, and then because we covered anonymization a bit in April, so next month, I'm going to give this hands-on data anonymization workshop. So the workshop is free for anyone with an internet connection, so feel free to join. All right, I don't know if there's any comments from Maria. You feel free to unmute yourself. But if there's nothing to add, we can now look at the practical step-by-step on how to handle and how to deal with personal data in research. So again, if you need to leave, this is the single slides take-home message from this presentation, which basically it's the step-by-step process from the planning, from the idea stage to publishing the data when possible, or at least, publishing your research with personal data. We will cover all these steps. You might find other checklists and other guidelines in other websites. For example, here, this is the Finnish Office of the Data Protection Ombudsman. In here, they have 10 steps, but many of these steps, they are actually part of the same process. For example, this planning stage where you plan the lifespan of personal data, choose the basis of processing of personal data. I will soon talk about these things. Or implement the rights of the data subjects. So all these things are, for example, taken care in the privacy notice, which is one of step in the process. So the process that I'm following here in this slide is like the chronological order of all the steps that you need to take from the researcher's perspective. But still, I think it's very interesting to also look at the information that you find in the Finnish Office of the Data Protection Ombudsman, because there are good reflections, for example, on the lifespan of personal data or on the rights of the data subject, that even though you might be familiar with this thing, it doesn't hurt to check these 10 pages. They're very short, so I highly recommend going through this 10 if you work with personal data in research in Finland. All right, so the first step is the planning step, the data management plan, but also data analysis plan, not just data management plan. So data management plan, you might already be familiar with them. The idea is that you want to describe the data that you are going to work with and the life cycle. Usually data management plans might have, or usually they have 6 sections where you first describe the type of data that you work with. You might mention some ethical and legal issues, like in this case with data from humans. There can be both ethical and legal issues. And then the planning for storing the data, eventually opening, not fully open, but kind of fair opening of the data and sharing, and some responsibilities. So the data management plan is good. It's not just an exercise. It's also an opportunity, if you're starting a project, to think of all these steps and to plan accordingly. If you know that you have very sensitive data, maybe you want to think or find the best storage solution for that data and not just store it on an encrypted USB stick. However, what about the data analysis plan? So now I'm going to talk a bit about pre-registrations. So the idea is that the data management plan tells you the plan for the data, the life cycle of the data, but you can be even more detailed and more transparent on what you're planning to do with the data. And this is usually done with pre-registrations. And in publishing, there are also the so-called register reports. So pre-registration basically show the transparency of your scientific reasoning. You show what is your hypothesis based from the literature, or you feel if you don't have an hypothesis, maybe you have an exploratory plan because you have a hunch and nobody has ever studied and you want to do an exploratory analysis of your data. In pre-registration, you can actually write in details the methods that you will use to test the hypothesis, which literally would mean showing which software packages, which tools, or which, whatever frameworks you might be using. In the registration, you can also specify the collection protocol of your data. Are they interview? Are they questionnaire? And eventually even do a so-called statistical power analysis. So do you need 10 people to get, enough statistical power that your whatever hypothesis can be actually tested? Or do you need 100 or do you need 1,000? Sometimes you might run a pilot study so that you can, for example, estimate the power or the effect size of your hypothesis, and that is usually helpful. So the pre-registration is kind of very close to the data management plan, but it goes a bit deeper because this is more like a data analysis plan. You need to look at the past literature. You need to look at the methods in details. You can't just say, I'm going to use, I don't know, magnetic resonance image. You need to explain how you would use it and which type of sequences and things like that. And of course, the registration, the data analysis plus also test the feasibility of the project. If it's clear that your hypothesis is too far-fetched, maybe the effect size of your question is so small that you might need to measure 1 million people to get something that is meaningful. Finally, registration don't need to be public, but of course, if you want to publish them, there are places like the Open Science Framework where you can basically post your registration. And all what I'm talking about here, all happens before the actual study. So here we are at the planning stage. We don't even collect the data. We didn't even, do anything, but we already have a plan. You can even think that you want to put a timestamp that this is your idea, this is your hypothesis. You want to make it public even before collecting the data. And then you might get feedback, and then you might get reviews, and the reviewers might point out some, details that you might fix. And this is then we go to the so-called register report, where you can get feedback before starting everything. Final comment on the registration, they have been recommended a lot in the open science community as a way to fix reproducibility issues, replicability, p-hacking, harking. I'm not going through all these terms. We actually have I'm going to give a lecture on this on responsible conduct of research as part of this same series. But the issue, of course, pre-registration will not save you from bad science. If you are measuring something that is wrong, you might still be able to produce replicable, reliable numbers, but that doesn't mean, that the validity of what your measure of your construct, is actually there. Here are some links. You have the slides. You can check them later. So this was the planning stage. You have planned your data lifecycle. You have planned the analysis that you want to do. And now you need to basically start with the real study. And the thing with working with personal data, you need to be transparent towards your data subjects, and we do that through the privacy notice and the consent forms. So data subjects must always be informed for which purpose and how you will process their personal data. And you do this by applying a legal basis for the processing of personal data as described in the GDPR. So the information to be provided slightly varies depending on whether the data is collected directly from the data subjects or if you get it from other sources. I'm not really covering this type of cases where you might get data in a sense that it's like secondary use of existing data or data from registry. But here in this 1 hour that we are together, I'm covering more the cases where you actually are directly collecting the data, whether you are meeting the person interviewing them or whether you are sending questionnaires directly to the subjects. So planning again is key. So the privacy notice, it's still kind of a plan, but it's a plan that you write not for yourself, not for the reviewers of your paper. It's a plan of the life cycle of the data for the data subject so that they know what's going on. And you might tell exactly what type of personal data you are collected and what you will do with the data. Of course, this should be described in a way, you can't use the same language that you would use with the reviewers of your paper. You need to explain it in a simple way. What is the plan with the personal data that you are going to collect? Also, you need to specify who is the controller and processor of the data. Usually this is Aalto, but sometimes this is not the case. You might have a project from outside Aalto or a joint project between Aalto and other organizations. So, there are different cases. And then, and I will talk about this a little bit more later, you need to pick a legal basis for processing. Usually in scientific research, we pick the public interest, but in some cases, we also use consent as a legal basis. There are other legal bases, but here we're not going to talk about the other ones. And then, of course, in the privacy notice, you also want to tell, for example, if you share the data with anyone outside Aalto, it doesn't mean simply collaborators or future, reanalysis of the data. This could also mean that you might be giving the data, let's say, they have interviews and you want to use an external service for annotating, for transcribing the interviews. So all this should be transparent to the subject. Also, if the data is going to leave the European Union, how long you will store the data, and all this other question that you see here. So I talked about the legal basis, and this should be specified in the privacy notice. For those at Aalto, in the same webpage that I mentioned at the very beginning, you also get nice templates for starting for writing your privacy notice. There are two types of legal basis for personal data processing, and usually most of the time we use scientific research, meaning public interest. However, we recommend for master thesis where the master student is not a researcher, so employed by Aalto, then consent is the legal basis for personal data. It's a little bit more strict. We can comment on this later in the Q&A section, especially if there are master students here or if there are supervisor master thesis. But let's say that usually most of the time public interest is what you want to pick. And then a good thing, because privacy notice is something you give to the subject, you might give it as a printed sheet when they come to your experiment. You might include it on a web questionnaire, but it's also good to publish them. So at Aalto, we are trying to publish all the privacy notice for ongoing studies and also privacy notice that are not related to studies on a single place. So that as a data subject, you know that you can go back there and maybe read again what you kind of accepted when you took part into a study. So some consideration on the processor. So legal obligation arise under the GDPR. So it's always, most of the cases for people at Aalto is the controller and the processor of the personal data. But sometimes, as I was saying earlier, there might not be, let's say, employee-employer relationship between the researcher and Aalto, and so those cases might be different. That for example, that the controller or the processor might be an actual individual who is collecting the data and processing the data. So if Aalto University is the controller or processor of the personal data, you also need to remember that you cannot take the data with you without separate arrangements, because then Aalto becomes the kind of also protector of this data. And if something goes wrong with this data, it's the responsibility of the data protection officer and Aalto University. So in a way, data is, if Aalto is the controller, then Aalto, if you need, let's say that you finish your doctoral studies and you want to continue on with using the same data in a postdoc in another organization, then you need to prepare so-called data processing agreement or data transfer agreement, so that the personal data can, for example, be moved from Aalto to your next organization. And actually, yeah, I was a bit too fast. This is exactly the next slide. So when it comes about taking the data outside of Aalto University, the personal data, again, you always have to be transparent with the data subject. So if you know that, you might prepare a privacy notice today and you didn't know that you were planning to take that data somewhere else, but you can still update the privacy notice and post it on a website, so that there is still a way to be transparent towards the subject, even though you might not be able to actually contact the individual subjects. Usually the DPA, data processing agreement, is the best tool that kind of makes sure that, for example, the organization where you're giving the data, they also have a similar system that they can basically, follow the level of that follow the same level of security that we have at Aalto, and we are following the GDPR. And as I mentioned already earlier, this is also relevant not just when you are leaving Aalto, going to another institution, or if you have collaborators in another institution, but also when you might be using a service, an external service, let's say a company who does transcription of your interviews. So that also, before giving the interviews to the company, you need to make sure that there are data processing agreements between Aalto and the services the external parties. One important thing that we mentioned, consent as the legal basis, but that is not the consent that is usually meant when someone consents to participate to the study. So the consent to participate is more related to ethics. This is why when you collect data from individuals, you have then two documents. You have the privacy notice, that is a notice that the data subject can read and learn what's going to happen with the data. But then you have the ethical consent form, so that you are basically asking the subject, explaining the nature of the study, explaining what is the hypothesis, what are the research questions, and then asking them for the consent to participate in the research. So it's important not to confuse that the legal basis consent is not the consent to participate in research. So, and in general, yeah, from the Article 13 of the GDPR, generally we don't need to obtain consent for the processing of personal data if the legal basis, for example, is public interest. So you want to obtain the consent to take part from the subject to take part to your study, but they don't need to consent for the processing of their personal data. There's an exception that we say that most of the studies we recommend using public interest as a legal basis, but for master students and bachelor students who cannot basically be considered that they are performing scientific research, so they are not part of a research group, they are working on their own, then the student is basically the data controller, the responsible of the personal data that they are collecting, and then consent is the legal basis that should be used. Then the data subjects with consent compared to to what's the other one, to public interest is a little bit more strict, in which basically the data subjects have the right to withdraw their consent of the process of personal data. And again, this is not the consent, the ethical consent, because that is always given that you still have the ethical right to withdraw your consent to be part of a study. But here it relates to the process of personal data. If consent is used as a legal basis, then the subject have the right to withdraw the consent of the process of the legal data. For registry-based research, where basically you're not interacting with the subjects, then consent is not possible because you are not able to obtain explicit consent from the people that you're receiving the personal data. A final reflection on consent: the European Data Protection Board explicitly says that consent as a legal basis should be freely given. So if you're going to use consent as a legal basis, you should not, for example, give a reward to take part of the study. Because if there is, as they write here, the use of enticements, inducements, or rewards to elicit consent may call into question the extent to which such consent is freely given. So if your study is giving, let's say, a lottery or a movie ticket or something, or a voucher for food, then maybe consent cannot be used because the consent cannot be freely given. There is some reward that is given to your participant. And this is also valid, especially if you are studying populations in poor condition of health, or they belong to a socioeconomically disadvantaged group. They might feel the pressure of giving you the consent, or they might, let's say that you do an intervention, or you're testing a new drug, and there then the consent, I might not be freely given my consent to join the study. I'm actually want to join the study because I want to get test some new medicine for my health condition that I'm not able to find a good medicine. I also heard this type of that even using the emotional pressure to the subject, for example, you will make the world a better place by taking part in my study. Even this then makes the consent not freely given anymore. And so consent as a legal basis in practice should be used very, very rarely, where public interest is really not possible to be used. So another last thing on these privacy notices before we move to the other step. Sometimes there is the need to also attach a DPIA to your study, to your planning of the study, because at this stage we're still planning. So the DPIA is the Data Protection Impact Assessment, and there are basically two dimensions that are usually assessed in a DPIA. The severity of the impact, which would basically mean, if something goes wrong, if there is a data leak, if all your personal data that you've been collecting suddenly is public on the internet, what is the impact for the data subject? Is it minimal impact because it was just about, I don't know, if they liked some music, classical music versus heavy metal, or is it a serious impact because you collected their socio-economic status and other, their salary or whatever sensitive personal data? And then the other dimension that is considered in a DPIA is the likelihood of harm. So what is kind of, the chances that something could go wrong, meaning that, that let's say that it's very unlikely that something harmful can happen to your subject, or it's very unlikely that somebody, can get access to whatever system that you're using for collecting the personal data, or is it that there are high risks that, for whatever reason you are using something that it poses high risk for the subjects. So the DPIA sometimes is needed, for example, if you are working with many, many subjects. Let's say there is no good number, but rule of thumb could be if you are processing personal data for more than 500 people, then it's good to also prepare this type of assessment exercise. In general, this severity of impact and likelihood of harms, I think that the how can I say, sloppy cybersecurity practices are actually the highest risk. because we and your organization might provide you secure storage and secure system to make it very unlikely, let's say, that the data is leaked. But in the end, if you have very sloppy cybersecurity practices because you store all your password and all your passwords or whatever phone PIN and all this stuff is they're so very easy to guess. Or if you work in a coffee shop, you're processing personal data while being in a coffee shop, and then you leave your laptop open and just leave to go to toilet. All this type of, all these type of issues, it's impossible to assessment. So with high, how can I say, with high risk comes also high responsibility from the researchers. And if you know that your cybersecurity practices are not the best, maybe it's good to talk with one of us and understand where you can improve your workflows on working with this type of sensitive data. All right, so we are still at the planning stage, and so far we basically prepare the data management plan and the data analysis plan. We prepare the privacy notices, the consent form to participate, and in some cases also the DPIA. Well, basically all these documents that can be attached to the ethical review at Aalto. So ethics is not law, as most of you know. Ideally, law would match ethics, but sometimes law does not cover something that actually ethics is covering. So in general, the Aalto is following the Finnish National Board of Research Integrity and their ethics guidelines, and the Aalto ethical review process does not cover medical and animal research. So for that, you need to go to the Esk University Hospital. When do you need to apply for ethics review? Well, usually or often there are 6 kind of points written in the guideline sections of TANG from 2019 that you should know by heart. If your experiment, if your data collection touches one of these points, for example, let's say that you intervene in the physical integrity of your participant because you attach them to a device where you're collecting heart rate or brain imaging of something, or let's say that you're working with minors, or you're showing exceptionally strong stimuli that can leave very strong memories. So in general, all these 6 cases listed here, they require an ethical statement from the ethics committee. However, these are not the only cases, because recently grant applications, grant agencies, and also some journals, they might require you to show that your study, that your planning, all these documents that you prepared, that they actually went through the ethical process. In that case, of course, it's an easier and faster process because you don't have any of these 6 elements listed here. But it's anyway something important to basically remember and to consider if you know they're going to publish on a journal that they absolutely require ethical review, even though in Finland it might not be a requirement. So for the ethics review process, I leave you, at Aalto at least, I leave you checking the pages. The next deadline is April the 5th for the next application. And especially at Aalto, we use a web form that where you can basically write all this ethical consideration, and all the documents that we've been mentioning in the planning stage. For example, the privacy notice, the consent to participate, the PIA, they can all be attached to this application form. So, well, this is just a screenshot of the form, even though we are working on a new one that most likely will be we will start to use it in August, or at least there will be a period where both forms will be available. But the content, actually, even though we have a new system, we're going to have a new system, but the name of the questions and the content is actually staying exactly the same. All right, then at this stage, we basically took care of all the, theory, of all the planning. Now, finally, we can actually start working with personal data. So then in a way, this part gets easier if you know what you're doing. Data collection, you are the expert here. You know which technologies your field is using, and you know what are the best practices in your field. Again, what is important is that you have good cybersecurity practices. Ask your colleagues, ask the people who are working with these machines that collect this personal data. If you're collecting surveys, ask for an opinion if the survey contains too sensitive data that maybe you don't want to run it over the web. What is important in the data collection stage is that the data is stored in a location that cannot be accessed publicly or by people who are not authorized. At Aalto, if you want to get familiar with the classification of information at Aalto, the same is also in many other organizations around Europe. Basically, personal data sits between the confidential and the secret information. And at the page that I listed here, in the link here, you actually get lots of different storage options on where to store personal data, and also how to encrypt it, and where not to store it, and things like that. So I'm not going to cover too much here about the data storage because we're going to have a dedicated lecture on this. But few simple rules to remember: that always be paranoid about the data that you have collected and the personal data you're managing. Encryption alone is never enough. Okay, encryption is good, and we're always be told that we need to use encryption. But if whatever encryption system, if the password can be easily guessed, if your laptop is always unlocked, and encryption is just an extra click that somebody has access to your passwords and laptop, and whatever is able to decrypt the data. In general, do not store personal data in a physical location that is accessible by everyone, even if it's encrypted. I understand, of course, that with Aalto laptop, the hard disk is encrypted, and many of the kind of disks that you see there, they're actually not physically there. They are cloud storage. But in practice, as I write here at the end, the higher the risk, the higher the security. Maybe don't even use a laptop if you know that you're really working with very sensitive data. So here also I mentioned that it's good then not to store the data locally, but to use the cloud. But also here be aware that there are different types of clouds. So the cloud that Aalto has from Microsoft is kind of good enough for this type of GDPR compliant storing, but other types of clouds, let's say Google Drive, is not recommended by the Aalto security team. So again, you can familiarize with these topics in the link that I gave earlier on the cybersecurity practices that we use at Aalto. And especially, this is the weakest point that I was saying earlier: do not store passwords in your laptop or phone. They're so easy. Once a password is stored, it can be hacked. It's very simple. And even phones, you might have a code, a PIN to unlock your phone. That is also very easy to, somebody can just sit behind you and check what is the code, or look at the fingerprints in your screen and guess how to unlock your phone. So again, the higher the risk, the higher the security, and maybe don't even use laptops or phones for storing how to then access this sensitive information. All right, now, of course, good, we have the data. We need to also process the data, because you might be doing some statistics or whatever, annotation, transcribe the interviews to anonymous text. So in general, again, here, of course, you are the expert and you know what you want to do with your data. But what is important at this stage, if you already didn't do it in the data collection stage, is data minimization. So with data minimization, we mean that if you don't need a certain type of data, then just don't even collect it, don't store it. If you don't need the social security number from an individual, there's no point in asking it. If all you need is an email because you need to contact them again, then just store the email. You don't even need the name and the surname. So in general, think of the data that you really need and just keep it at the bare minimum. This is the minimum of minimization. Of course, data minimization techniques depends on the data that you have. And again, you are the expert here. Let's say that you work with magnetic resonance images of the head, then yes, you can minimize some of these MRIs, for example, by blurring the facial features. So you know which data you need. I'm not saying that you should always remove facial features, because sometimes people might be actually studying facial features. So I'm not saying that minimization should always be done, but if you know what's your hypothesis and if you know what you need from the data, then you should throw away everything that you don't need, all the other personal data. Which basically means even at the data collection stage, do not collect and keep everything forever just because you never know. So these types of, in my opinion, it's a sloppy way of science. It means that you have absolutely no hypothesis of what you are searching for, or that you just want to do a big mega exploration of everything. There are data sets that keep everything. So if you really have an hypothesis on a big fishing exploration, everything, maybe start with those data sets like the UK Biobank. And then maybe from there, you can build an hypothesis and see which type of data you need and then collect just that. And basically, yeah, I mean, all these topics will also be covered in the data anonymization workshop that we will have in next month. Well, we don't need to go to this, but basically this is related to what we were talking earlier about direct identifiers, indirect identifiers, and kind of strong indirect identifiers and just weak indirect identifiers. So when it comes to anonymization, there are different recommendations, whether you just destroy them or you can, pseudonymize them with them. But we don't need to cover this right now. And then for the actual processing that you really need to, run some statistics on your data, then what is left is still personal data. And you might now be thinking at the workflows of your data analysis. We have a page under the Aalto Scientific Committee on this type of data workflows and when secure data is needed. In general, don't use your laptop and use some remote system. At Aalto, we have VDI, for example, which is good for data that is not too sensitive, or the Triton High Performance Computing Cluster, which is kind of similar to VDI, but gives you more computing power if you really need to, do lots of analysis. When things are getting very sensitive, and in this case, we haven't covered registry data or secondary use of data, but there are new tools by CSC, for example, the SD Desktop, which is another VDI system for those who have used VDI, that allows you, to be, or soon, a FIN data compliant. And at Aalto, we are also, Aalto IT services are also soon done with the FIN VDI, which is our, again, secure computing system. Once more, the higher the risk, the higher the security. So if you know that you have 1 million people, a data set with 1 million data subjects and sensitive data from them, then maybe you want to use SD Desktop or the upcoming FinVDI. If you have 200 subjects and just some questionnaires, then any of these remote computing tools are fine. Again, if you're in doubt, come and talk to us when it comes to the computing and to research software. You can join us daily at the garage. We have a Zoom garage open. You can just come and ask anything. We are there every day from 1 p.m. And we help the whole Aalto for this type of data processing issues, not just personal data, even any type of code problems that you might be having. All right, some other comments on this data processing. So the thing with GDPR is that you also need to deal with the participant's request. So part of the processing is also keeping track of your kind of data processing duties, personal data processing duty, which basically means a participant might ask for the deletion of the data because they want to be removed from the study, a correction, and yes, for us, so they have the right to withdraw from the study. Sometimes it might not be possible anymore to re-identify the subject, and that's okay. The GDPR is not telling you that you should absolutely re-identify the subject. If you deleted most of the identifiers and it becomes very difficult to re-identify the subject, you're not supposed to collect more data just to basically follow the duties of the GDPR. In some rare cases, it's possible to deviate from some of the subject rights. Let's say that, I don't know, for whatever reason, what you're collecting is so important that you don't want to give the option of the deletion of the data. But when things deviate, you need to prepare a DPIA and you need to get the opinion on the ombudsman. And then finally, another duty, this is maybe more ethical rather than legal, is the incidental findings. So sometimes you might, especially if you're collecting medical data or health data, you might find something that could be used as a diagnosis for the data subject. Of course, this is not your task, but you might need to have a procedure on how to deal with incidental findings. So, for example, you can point out a medical doctor who can then look at the data and eventually talk with the data subject and point them to health services. All right, we're basically done. 2 o'clock. The last step is that you analyzed your data, you collected your data, you analyzed your data, you made nice figures, you published the paper, and now you might be thinking, can I publish the data, the personal data with the paper, or can I share it? Can I share it with other scientists who might want to reanalyze my data? So in general, the answer is no when it comes to GDPR. So we cannot usually, openly upload the personal data of a study, even though you pseudonymized it, and just let everyone reuse it. If it's fully anonymous data, then it's not personal data anymore, and then yes, you can share it. But what is important is thinking of the FAIR principle. So findable, accessible, interoperable, and reusable, which basically means that you should open the information about the metadata. So where is this data set? How can I access this data set? Because of course, it's not just you in a research project. There might be other people who might join in the future and you might have left. So it's important that you clearly stay where is the data, and if somebody wants to reuse this, what should they do to do that? Then, of course, often we get these cases that the personal data should be shared with a EU partner or other institutions, and this can be done more or less freely in a sense that there should, always be a document like a data processing agreement that you make sure that, again, you just want to be transparent, that if eventually one subject comes back and asks where my data went, there are documents, there are agreements where you can show that, yes, okay, the data was given to a university in Germany and we have an agreement with Aalto and everything is fine. And the same story is basically also for non-EU. And when it comes to data opening, then things get a little bit more difficult. So it is not possible to open personal data per se, as in make it fully open, but by making the data available on request, so by making the data fair, we can have a process that is still kind of, open, but protects the data and the data subject. On this case, I didn't have it here because it's not ready yet, but CSC are working in SD Submit, which is going to be a platform in Finland, at least for Finnish researchers, where you can upload your pseudonymized personal data set, and then it will be available on request, which doesn't mean that they will email you and you will decide I give the data only to my friends. It's actually a process that will be between, for example, CSC and a data steward at Aalto, where CSC will deal of the request, and then the data steward, data agent, whatever data person at Aalto can discuss with the research group, for example, or with the ethics committee or with the legal experts, can we give access to this data to these people? It's still work in process. I was talking with the CSC people this week actually, and hopefully towards the autumn, we might have something that we can actually basically publish personal data in this, in a secure way. In other countries, they went for other options. So for example, at the Donders in the Netherlands, they built a system that is based on data use agreement. So here there is no ethics or legal committee that decides who can access the data, but it's more that through basically accepting a data use agreement, people are allowed to download the data. I would say that again, this is not super clear. We are still waiting for the European Data Protection Board to give an opinion on the kind of secondary use of data, which I'm not really touching in this presentation here. And of course, the reusing of data always leave ethical implications, because we always promise our subjects that don't worry, with your data is securely stored and whatever, but when the data starts to leave Aalto and go in other places, we have less control on possible data leaks or other abuses that can be done with the data. All right, so we are done. 2:06, so there's plenty of time for discussions. So in general, the recommended final process is that plan well, think of your data management plan, and also pre-registration if you want to plan the full analysis pipeline. Plan and design your privacy notice and the consent to participate. If needed, get an opinion from the ethical committee. And of course, this is a statement. This is an opinion. It's not that, it's not a stamp that lets you do whatever you want to do. And then you can actually, collect the data, process the data, and hopefully also publish the data. One final note that long-term archiving of personal data is not yet established. I think this is still of an open issue because the GDPR and in general, we never say that something is stored forever. But then we start going towards other systems like biobanks or data banks. Do we, is the data in a biobank or data bank stored there forever? We don't know yet. If we think of the service of CSC, the SD Submit, they will provide long-term archiving of the DOI, of the digital object identifier of the dataset, but that doesn't mean that the dataset itself will be there forever. So this is still an open issue. All right. Now we can take questions, and of course, we can stop the recording for now and let people talk freely, raise their hands, and